We'll take your calls tonight. We have 2 lawyers in the studio tonight, and let's quickly find out from these 2 lawyers the implication of Section 84, subsection 12, and what the Senate has done tonight. I have joining me Barrister Tochukwu Ohazurike. Thank you so much. Welcome. You, and with him is Barrister Vincent Otapoku. Thank you, Barrister.
Thank you for having me.
Yeah. You remember, Barrister, we're almost talking about this Section 84.2 the last time you came.
Yes.
And today the Senate has, you listened to their voice.
Yes.
So what do you have to say? Anyway,
their position today is not far from the expectations, the constitutional expectations. The power to make law is constitutionally bestowed on the National Assembly, the Senate, and the House of Representatives under Section 4 of the Constitution. And it is their prerogative, constitutional prerogative, to decide which law to amend and which law not to amend, which executive bill to consider and which executive bill not to consider. I look at it as a kind of, the president was just maybe making a soft letter to them, because you cannot approach the majesty of the National Assembly in their constitutional aura, based under Section 4 of the Constitution, as a law-making body of Nigeria, by mere letter. That is the first problem.
But this is not the first time it is happening. The president has written to them several times.
For the first time it has happened before, I thank them today for standing to say, we reject this. For me, approaching the National Assembly through a letter is wrong.
So you want the president to go there by himself?
No, there's a way you can approach them. There should be a proper bill sponsored.
Okay.
Executive bill. They can sponsor executive bill and request for amendment. Request for amendment, because the president or the executive cannot dictate for the National Assembly, because the powers of the executive is bestowed on them by the Section 5 of the Constitution. So, by the principles of separation of powers, every arm of government has a constitutionally bestowed responsibilities listed under the Constitution.
Okay.
So, if you want to approach the other arm, it should just be a request. But the sovereignty and their power to make law under the Constitution, it rests on them, which they have done today. I do not see anything in that section
that contravenes the Constitution. Section 40 talked about the right to assemble. Yes. Section 42 is talking about the person's rights.
Yes.
And you think it doesn't infringe on the right of the person?
There's no infringement to me.
What about the section that talked about maybe resigning from office 30 days before time, before election?
Before election.
This time, not primaries.
No, you know, every provision in the Constitution is to checkmate a mischief. There must be a mischief which this letter amendment, which is now a law, is seeking to correct. There have not been this. We have not had this controversy with respect to persons, resigning 3 months to contest an election. They want to just, promote sanity in the system, such that persons in authority holding executive office will not use their power to undermine democratic principles and democratic
processes.
Processes.
All right, Barrister, I know you've been smiling, and I was wondering what you have at the back of your mind. Section 84.12. Yes. It's been so much noise around this section.
Now, with what has happened today,
yes,
it will be taken that Section 84.12 is part of the body of our laws now.
Okay.
However, as much as, like my colleague has said, there is a mischief it intends to correct, I would ask the question, was it correctly done? If you want to correct a mischief, you don't cure it by another mischief. Section 84.12 directly contradicts and violates the provision of the Constitution that says if you are an office holder, an appointee, you should resign 30 days to your election. That provision of the Constitution, which says 30 days, should be the only limitation to an office holder. to leave office, not any other law. Now, there's a current constitutional amendment process in the National Assembly. Why didn't they just amend that section in the Constitution and leave it in the Electoral, and not put it in the Electoral Act? Why not just amend it in the Constitution? That 30 days in the Constitution. The Constitution has said 30 days. You remember, hitherto there was, people were asked to bring their tax clearance certificates before they contest elections. But it was on issues like this that the court said, no, the Constitution has stated the qualifications. Anything outside that constitutional provision, nothing. Again, when you talked about the issue of, but I like it though. How I wish they had just amended the Constitution to put section that, the lines and letters of section 84:12 in the body of the Constitution. It would have been perfect. Because people who are in office, one, not just that they are using state resources to contest elections, the distraction and the time out of office that they will be in their constituencies campaigning, particularly, okay, now somebody who is running for a presidential election will now need to move around the country while the job suffers, and the Nigerian people are suffering. You understand? You can see the fuel situation, no lights, people are burning generators, buying fuel at exorbitant prices, probably because people who are supposed to do these things are interested in one political office or the other. And the people have to suffer it. So when you look at the body of this thing, you see that it's a good thing, but I think it was wrongly done. And I can tell you, before the elections, Nigeria will not have section 84:12.
Before the elections. But let me
before people will resign.
Let me say
before
this.
people will resign, Nigeria will not have section 84:12.
Let me say this. The primaries for presidential elections,
yes,
will start April 4.
Yes.
That's less than a month.
Yes.
And once they start that primaries, that section holds. Are you aware of that?
Yes.
Because people will need to resign.
Yes.
And respect the Electoral Act.
Yes.
Because there are those who have said...
Nigerian politicians are easy to predict.
But let me ask this question too. That section you're quoting, 30 days before election.
Yes.
You know it has nothing to do with primaries.
It doesn't connect primaries.
And this is about primaries of political parties.
If I am an office holder now, I will refuse to resign. And I will tell you the Constitution did not demand me to resign. The Constitution says I should only resign 30 days to my election. Where this thing got this loud voice was in the case of Governor Fayemi, who as Minister of Mines was in office, won his primaries 30 days to election before he resigned. It was that particular outing of Governor Fayemi that made the National Assembly to consider this.
It happened in Anambra. An APC aspirant went for the election, went for the primaries.
No. Fayemi's own is that he won the primaries. So
yes.
while he was the holder of the ticket, he was also the holder of the office.
Yes.
That's why I'm creating the Fayemi issue. Now, that one was what brought it to the fore. But the National Assembly should have taken this thing through a constitutional amendment process. Put the two provisions together. The Constitution says I should not resign to contest primaries. I should only resign to contest elections 30 days before election. And then as under law, lower in class than the Constitution, which says, no. Before you resign for Constitution, that means if we continue to obey this one, that provision in the Constitution is useless because nobody will need it. Because we would have all resigned before primaries. Meaning that provision in the Constitution is useless.
Okay.
And that is what the Constitution will fight against. And I trust Nigeria. President Muhammadu Buhari, having voiced it out when he signed, and also caused a letter to be written. He has
but the sections that he quoted have there are lawyers who say they don't have relationship.
What he quoted is wrong.
They don't have relationship with this.
There's a recent court judgment about an unmarried police lady who got pregnant.
Yes.
NBA took up that matter, you recall. What was the holding of the judge? That the woman knew the rules of the police before she joined.
Okay.
Do you understand? That the woman knew the rules. So if you knew the rules and you join, you now come and say, no, it violates your... No, it did not. Likewise, if this had been a constitutional provision, it would have been that you knew that 3 months to primaries you should resign. So don't come and cry when you are now in the office already enjoying the largesse. You now come and tell us it does not violate any rights. All right.
That's that. Let's quickly go to other issues at this moment. Nigerian women are still agitating for their bills to be revisited. Why the House of Representatives has given it a nod that they will revisit some of the bills. Meanwhile, the coalition of United Political Party has added their voices in support of Nigerian women on their gender parity bills rejected by the National Assembly.
Family, Senator Iyachu is pained by this parliamentary decision and have since commenced action towards mobilizing our lawmakers on how best to deal with the challenges posed by the rejection of the bill. The opposition is also working hard to create more participation platforms for women internally. If elected in 2023, the opposition coalition shall address the issues of women participation that led to the presentation of the pro-women political participation bills that failed. As we celebrate our women, we wish to express our sadness once again over the decision of the Parliament to reject those pro-women bills and call on the National Assembly leadership to reintroduce those bills for the sake of our democracy and women's participation in democratic process. Thank you. It is another opportunity to reflect on how far we have come as a people in giving our women the pride of place in our society in conformity with relevant best practices. It is an occasion to reaffirm our support for implementable affirmative action for our women and to further re-emphasize our firm resolve to end all forms of gender-based violence within our powers.
Spokesperson of the Coalition of United Political Party there, Barrister Ikenga Ugochinyere, Imo. Well, let's go to Imo State, and the report we have from Imo State is that Unko Okpala, the new House member who won the election, even though they are still contesting that, has been sworn in.
I am going to abide by the rules of this House, and whatever that has brought this House together, I will be part of it, and I will contribute mine to make sure that there is love and peace exhibited in this House. My name is Dwight Amajiro Okane, representing the people of Ebonyi State constituency. God, we contribute our best to the development of the state through the legislature. Yeah. It's politics, you win some and you lose some. It's just that all of us must come back and join hands to develop Ngobala. Ngobala is highly marginalized and underdeveloped. So we need everybody on board, we need every hands on deck to make sure that we improve the living standard of the people there and other developmental projects that we will appeal to the state to actually come to our aid. A lot of experience. I've been in this system, I've been around the state, I know where we should do more, so I'm going to bring a lot to the table.
Let's move over to Osun State. As of Tuesday, the People's Democratic Party held its party primaries to elect standard bearer for the July governorship election, but it appeared that it was parallel convention, parallel primaries, just like we saw in Anambra State. The two primaries came out with their two candidates. That is also a legal battle too. Let's see it.
Generally, by the grace of God, the two parallel lines will meet very soon. We will resolve it. It's a family disagreement, shade of opinions.
Few people are assembled and they are doing merry-making party and all that. What would you call it, a Congress?
By the powers conferred on me as the chief returning officer of these gubernatorial primaries, we hereby collectively declare Adeleke Ademola.
I call on everybody to join hands together with the good people of Osun State. And by the grace of God, PDP will win on the 16th of July 2022.
As law-abiding citizens of Osun State and law-abiding PDP members could not participate in an illegality.
Hello there, I am Enemaku Ojotibe. The Nigerian Senate has rejected Buhari's request to amend Section 84, Subsection 12 of the newly signed Electoral Act. Join us for these and more in the news tonight at 8 p.m. on AIT.
And now to our main focus for tonight.
I feel so sorry for the judiciary. The executives may have problems, the legislature may have problems, but the moment justice could be purchased, then we are in trouble in this country. And the ruling is a clear evidence that this country is in trouble. And let me tell you that this same judge has over 10 cases against Ebonyi State Government with him. And you can imagine what is going to rule. We have petitioned him to NJC, and we will follow it up at all costs.
Yes, the Nigerian Bar Association has described the reaction you just saw here now by the governor of Ebonyi State, Dave Umahi, to the court order which sacked him and his deputy, Dr. Eric Kelechi Igwe, from office as impunity of the highest order and executive rascality taken too far. This was contained in a statement released on Tuesday by the president of the association, Lumide Akpata. The statement reads, let me quickly take it. The Nigerian Bar Association, NBA, has noted with utter dismay the unfortunate and totally unacceptable reaction of His Excellency Dave Umahi to the judgment of the Federal High Court, Abuja, delivered on 8th March 2022. Quorum Honorable Justice Inyang Eku, which inter alia ordered him and H.E. Mr. Eric Kelechi Igwe to vacate the offices of Governor and Deputy Governor, respectively, of Ebonyi State on grounds of their defection from the People's Democratic Party to the All Progressives Congress, APC. Following the judgment, Umahi, in the course of a press conference, video evidence of which is currently making the rounds on both new and mainstream media, threw caution to the wind and deployed very uncomplimentary, adjustive and intemperate language in characterizing both the judgment and Honorable Justice Eku, including but not limited to describing the judgment as jungle justice and his lordship as a hatchet man. As if this were not enough, Engineer Umahi accused the court of murdering justice and also arrogated to himself the judicial powers and the magisterial authority to declare the judgment of a court of competent jurisdiction as null and void, while unashamedly, yes, declaring his intention to disregard the judgment in favor of another. To put it plainly, this is impunity of the highest order and executive rascality taken too far. While the NBA has absolutely no interest in the outcome of the case in question and will continue to stay away from partisan politics, it is inconceivably and that this association that is charged with upholding the rule of law and defending the judiciary would sit idly by the face of this unprovoked and totally unwarranted attack of the judiciary. Indeed, the leadership of the NBA has been inundated with calls from a cross-section of well-meaning Nigerians who are understandably outraged by the utterances of Engineer Dave Umahi and who have rightly demanded that appropriate action be taken to protect the sanctity of the judiciary. It is for this reason that we condemn without equivocation Engineer Umahi's unfortunate diatribe, which, if it had emanated from an average litigant, would still have been regarded as shocking, but coming from one who occupies the exalted office of a state governor is nothing short of a national embarrassment. In the wake of the judgment, one would have expected Engineer Umahi to sue for calm from his supporters and to ensure them that all legal and constitutional avenues would be explored to challenge the judgment. For H.E. Engineer Umahi to instead resort to attacking and denigrating the high office of a judge in this unprecedented manner is disgraceful, undemocratic, and completely unacceptable. As Kayode SOJSC of blessed memory famously noted, the essence of the rule of law is that it should never operate under the role of force or fear. We view Engineer Umahi's reaction to this judgment as being consistent with the current penchant on the part of those, the executive arm of government, for intimidating the judiciary with taking advantage of the historical reluctance of the arm of government to rise to its own defense. In light of the foregoing, the NBA hereby demands an immediate apology from HE Engineer Dave Umahi and a retraction of the comments he made against the person and judgment of the Honorable Justice Nyang Eku of the Federal High Court. It is also our demand that this apology and retraction be given as much media coverage as the press conference where the unfortunate comments were made. End of quote. But this was a statement released and signed by the president of the NBA. And the outcome of the Abuja Federal High Court has attracted divergent reactions among legal experts. While some say the judgment is a test of Nigeria's democracy, others are of the view that it was an error. Before we bring back our guests in the studio, let's see the position of the People's Democratic Party on this.
We call on the Chief Judge of Ebonyi State to immediately swear them in as soon as INEC issues the requisite certificates of return. And lastly, we call on INEC to immediately withdraw the certificates of return from the 17 lawmakers and commence the process of conducting by-elections to replace them. We want to appreciate the Nigerian judiciary for this landmark judgment. The ruling will bring order in the political space and check the issue of political rascality and stolen mandates. The judiciary is indeed the backbone of this democracy. We also want to single out Justice Nyang Eku for special recognition, particularly for being courageous and forthright in going for the substance of the law rather than the technicalities.
National Chairman of the People's Democratic Party, Senator Aichu, are you there? And our guests are still in the studio, Barrister Tochukwu Hazurike and Vincent Otapupu, both ex-choirs. Thank you so much for remaining with us on this program.
Thank you.
So,
Thank you.
Let me start again from where I started from. Barrister Vincent,
yes.
This is, can I call it a novel one? Because it's the first kind of judgment in Nigeria. In the history of, yes. But when you look at development playing around this whole thing, what do you have to say?
First of all, IJ, this issue, the judgment of the Federal High Court delivered yesterday has provoked an exciting scholastic disputations with its attendant, like you've read from the NBA position, contentious issues and responses. Beyond this point, I want to lend my voice to the position of NBA to say that I have always maintained that position, that in a democracy like ours, rule of law must triumph over not only in our legal system, but in our body politics. Parties to a litigation must accept decision of court in good faith, subject only to appeal processes available in law. No party should employ self-help to disparage or disrespect the order of court, including but not limited to the statement credited to the executive governor, the governor of Dave Umahi. You know,
why did you say sorry?
Okay.
He's executive governor.
Just leave that one. I will come to that point. Such that to discredit, to disparage, and disrespect the majesty of the judge that delivered the judgment. You must be able to distinguish between the person of the judge and the judgment so delivered. Beyond this point, for me, as a lawyer, practicing lawyer, I beg to disagree to some extent with the position of the erudite Federal High Court judge. I'd say this with respect to what is provided under our Constitution, where the Constitution has made a provision, where the law has provided for a thing, or whatever that cannot be seen in the Constitution should not be inferred for whatever purposes. There is no constitutional provision with respect to defection of a sitting governor to another political party. Consequences, sanctions, or judicial action that can be taken. Now, because from what we have seen, the People's Democratic Party canvassed opinion with respect to invocation of section 221, section 177C, section 106 and 165 of the Constitution. I know, like Justice Ududoma have said in Nafi Arabia against State, that the functions of the Constitution is to establish a framework and principles of government, broad and general, intended to be applied in a varying condition, of which the existence of our society must be involved. Ours being a plural and dynamic society, therefore, mere technical rules of interpretation are to some extent inadmissible, so as not to defeat the principles of government enshrined in the Constitution. That is, it is a written organic instrument made by the people of Nigeria in the assembly assembled to serve the generation and vet unborn. This quotation goes to say that a judicial officer faced with interpretation of a constitutional provision is at liberty to adopt a broad approach. You don't interpret one section in isolation without the other, and that's what the judge did. But when you look at the content of those provisions he relied on in executing and sanctioning that, removing the governor of Ebonyi State, I beg to disagree. I did not see anything, any constitutional authority, any constitutional backup that empowers such exercise. Section 6, subsection 6A of the Constitution, which borders on the inherent power of the courts to do and undo, even to make a man a woman, a woman a man, does not apply in this circumstance. I said this without missing words. Now, when you look at the provisions of the Constitution, we say in law, in our legal practice, that expressio unius exclusio otarus, the express mention of one thing is to the exclusion of the other. The Constitution, in its majesty and wisdom, under section 68(1)G, section 109(1)G, had made provision with respect to defection, that of the State Assembly, National Assembly, that is the Senate and House of Reps. A member who is elected to occupy office with the mandate of his people cannot abandon such mandate in the course of his legislative tenure and defeat another political party, except when there is a division at the national body of his political party.
So it has nothing to do with the government. I
agree with my Lord, the Nene trial judge, to the extent that his action on the House of Assembly of Ebonyi State is captured in law, is well founded in law, under section
So what it means now, sorry, let people understand.
Yes.
If you're disagreeing with the judgment,
yes,
it means that the members of the State Houses of Assembly that defected will have to resign their position. Because
they have to resign.
They have to resign.
I agree with him to that extent because it is constitutionally provided. But I fail to agree with respect to extension of that exercise to the governor of Ebonyi State.
But by South Africa,
the governor, let me land, sir.
No, you will land. You know, we are working with time here.
Just one point.
Okay.
Just one point. The Constitution of Nigeria does not make any provision with respect to this. Section 241 and 240 of the Constitution has given the governor or every litigant power to approach the Court of Appeal.
Yes, to appeal it.
And it's a constitutional right. So, as a governor, the dispute relating to this action, judgment, does not arise from his election. That is, either as he contested the election under and went to tribunal and moved to Supreme Court, or under section 87(9) of the Electoral Act and 31(5) of the Electoral Act,
okay,
as a pre-election matter.
By South Africa, let me just ask this question because I'll be going to Tochukwu very soon. In Kogi,
yes,
2016, September 2016, if I remember.
Yes.
You recall that when they lost the the supposedly candidate of the APC. Yes. That thing went to court. And the Supreme Court gave a judgment. I don't know if we have that report, because I had to screen grab that very report. I went to look for it, and I saw it online in one of the dailies. Maybe we just show the picture. The Supreme Court gave a judgment. And in that judgment, it says votes of election belongs to political party.
That is not the law.
Hold on. The PDP at this point went to the courts in Abuja to seek for who the vote belongs to. Yes, in this case. Is it the same thing with your position that you're taking? It's a totally different
It's the same thing. That's where I'm trying to arrive at that point, this point you have raised now. The case of Amechi and INEC, which considerably we have relied on, Supreme Court have maintained position that votes cast in every election belongs to a political party. That judgment of Supreme Court is no more the final authority today on that subject matter. Supreme Court have somehow seems to have deviated from that point.
That's in the case of Amechi
and INEC.
Then there's a case of Kogi that I quoted now.
Yes, I'm coming to that. The case of Kogi does not relate to this subject matter.
We'll
now, when you look at Akunyere and Ngige,
we will come back to you.
The Supreme Court said that vote belongs to the candidate.
Okay, we'll come back to you.
Because he canvass.
We'll come back. I will allow you to make your point. But let's come to Tochukwu. I'm sure you've listened to him.
Very well.
He has been able to establish that the judgment given yesterday was an error. So do you agree with that?
Absolutely not. I want to lend my view to the fact that the erudite judge yesterday considered the position of the law and the submissions of counsel of all the parties before him in giving a well-founded judgment worthy of every legal practitioner to have, time to read it, understand what the judge wanted to say. Now, clearly, it is not a doubt that the Constitution, 1999 Constitution, does not provide for the punishment to a governor, if any, or sanction, where he leaves his party to go to another party. But the fact that the Constitution does not provide for anything does not stop the court from looking into that thing. The courts make laws. When the Supreme Court made Amechi governor, there was no provision in any constitution that any person who did not contest for an election can be a governor. But the Supreme Court did that and founded it on the law and the Constitution. Until P2B reversed his impeachment, issues of impeachment, by the reading of the Constitution the way it was couched, nobody ever believed that it was a justiciable issue. The legal practice believed that issues of impeachment was not justiciable in our laws. But P2B went to court and said, no, it is. Read it again. And the Supreme Court read it again and said it is true, that you can do it. And you have seen it in several other states where even the CJ of a state has reviewed the process and said this process did not meet the dictates, the provision of the Constitution. Before the Supreme Court did that, it was a process that you could never look into. Once the House impeached you, you remained impeached. Now, let's come back to the issues at hand. There is no provision, yes. But PDP approached the court and said, my lord, we have a right here. We are by constitution, we are the only body that can sponsor a candidate, no other group, except a political party. And we indeed sponsored a candidate. He won this election. But he has taken the victory and the glory of our campaigns and manifesto to another political party. My lord, do we have a right? Have we suffered any injury? That was the grounds PDP went to court. People mix it with the Atiku issue. Atiku issue was the Attorney General went to court to say that by defection he has resigned. And the court said no. Supreme Court said no, he has not resigned. So the issues are different. The issues for determination are different. Those issues remain. So when PDP said that, the court looked at the defenses. And in the judgment of the court, when the court was reading that judgment, it continually mentioned the fact that the defendants were not attacking the issues presented to him. They were attacking emotions and sentiments. They were attacking emotions and sentiments and not the substantive law that was before the court. And that was why they did not attack the issues that were presented to the court. Now, when the court said that, okay, you can, now if you look at the alternative prayers it gave, because there is no provision, the judge is within his rights and jurisdiction, where there is a vacuum in law, to make a law that contains, that cures a mischief, that settles a present and life issue before him. So what the judge did was to say, okay, PDP, you are the winner of that election. You cited Akunyele and Ngige. Akunyele and Ngige was before 2016. It was before 2016.
CPC and Obadobwe too. In their letter 2017.
The Supreme Court said that Yahya Bello could have only inherited the votes of Abubakar Audu, may he so rest in peace, because the votes belong to the party. Now, if you cite 2017, let me cite 2021 for you. In Imo North, senatorial election, December 5, 2020 election, that was, the judgment came in 2021, I think around June 2021. INEC declared that election and declared APC winner without mentioning any candidate, because as at then, there was no known candidate of APC. But INEC, knowing that that is the position of the law, enjoyed by the APC that is now saying the party does not, do not belong to political parties, they were the beneficiary of the outcome of the Imo North senatorial election. And they took the glory of that. The vote belongs to APC. APC was declared winner without a candidate until Supreme Court resolved it.
Yes, I think I remember that.
Let us come to 2022.
I have a question.
February 12th.
I have a question.
Sorry, sir. February 12th, 2022. Local council elections in our own backyard there in Abuja, Abaji. APC was declared winner without a candidate. I'm not even sure if the candidate has not been declared. It is known even to APC that the votes belong to the political party.
So now, on the issue of this,
yes,
what Umahi said yesterday is, one, you can't take him to court because he has immunity.
That's where I'm
Number
coming
two.
That's the question I want to ask.
Yes, he said it. He made that statement.
How do you reconcile that?
How do you reconcile that? Number two, that the Constitution is silent, totally silent on the issue of defection of governors. That is another point. So can you tell us that, though, whether wrong or right, when a judge gives his judgment, that is final with that court. You cannot, except you want to appeal it, you cannot say it's not a judgment. But can we just look at these two?
All right, very
issues?
directly. Well, ordinarily, I would have wanted to say, please, anything that was said by Dave Umahi yesterday should be censored by Nigerian media, because what he said should be totally censored. What he said yesterday was not supposed to have been said by any reasonable man. We call a judge a hatchet man. But the only hatchet in this judgment was the one he did. This suit was filed in August 2021. Hearing was concluded by January 19.
Which of the suit?
This very one, the judgment came yesterday in Federal High Court. Yes. Hearing was concluded January 19, and the judge on January 19 adjourned to March 8 for judgment. Obviously knowing that they didn't have a defense and they couldn't have defended it well, on February 4, he got his party member to file a suit against him in Ebonyi State High Court.
Is that a fact?
I'm stating facts now. And got his party man, Obuoji, Senator Obuoji, to file a suit against him on the issue of the defection, that Dave Umahi should be sacked and that he should be declared the governor. On February 4, he got a lawyer from the office of the private chamber of the Attorney General of Ebonyi State to be the counsel that took Dave Umahi to court and his deputy. On February 28, 23 days after, having sat at the table, everybody signed process, they arranged the thing, filed it 23 days after judgment was given. That's the hatchet that is involved in this issue of whether he should be a governor or not. That's the only hatchet that happened. But in this one, he was asked to come. He came. He brought a senior advocate of Nigeria to represent him.
All right.
So on the issue of, so let's start what Dave Umahi said and look at the issues, because it's
no, but you can't take away that statement.
No, let's take
talk
it out. Ask me a question
Dave.
On Section 308.
That's what I'm saying now.
Other issues.
Okay, since you do not want Dave Umahi to
don't mention his name
to be referenced.
Yes.
So those sections you have quoted now, do you just wave them aside and say because it's a judgment given in court?
No, those issues are issues ordinarily that he should have that the Ebonyi State people should have canvassed in court. The question is, did they canvass it? If they did not canvass it, can the judge on his own say, I don't have jurisdiction because there is a section 308 that grants the defendant immunity. The defendant, obviously, him and his deputy had immunity before the judge. Now, and if the judge, I've not succeeded in seeing a copy of the judgment, but I know that there is no way a judge will look at that thing directly as it is presented and not say. Now you ask yourself the question, where there is a wrong, there is a remedy.
All right.
Now, could the judge have also looked at section 308 and said, despite the provision of section 308, now, because judges also amend laws, and now say, based on issues like this, which will now warrant the National Assembly, it has happened severally in our jurisprudence. Well, after judges give judgment, the National Assembly will now say, oh, if this is possible, then we will need to amend our laws.
All right.
Obviously, this has called to question the need for an amendment to section 308.
Yes, we've been speaking on the judgment delivered by Justice Ekbu on Tuesday, which sacked the Ebonyi State Governor, Dave Umahi, and his deputy. But let's quickly open up our reaction box. You can send in your reaction to my Twitter handle at EG or Samo. Follow me on that handle, and so you can send your reaction, or follow us at Democracy Number 2 Day with the double Y, Democracy Today with double Y to be part of the program. Call into the program on 0805 378 9021. 0805 378 9021. We just have our last lap of question here. So your reaction before we go, because the time is on.
Section 308 of the Constitution, which provides immunity for governors and presidents of Nigeria, is sacrosanct and has been interpreted in litany and cornucopia of cases by the Supreme Court of Nigeria. Supreme Court, in the case of IMTB versus Governor Bola Tinubu, it says, monetary allegation against Governor Bola Tinubu to wait until he vacates office. 1. The case of Asante Communication Limited versus Donald Duke. Supreme Court extended and re-echoed this constitutional importance to say a governor of a state, once elected, enjoys immunity. So that is the constitutional quagmire which has now been created. Right. Beyond this point, Section 141 of the Electoral Act has now been placed under a serious scrutiny. If by this judgment, the Ebonyi people have to go back to the pool to elect their governor,
Barrister,
the law says that the court should not declare anybody winner unless the person has participated at all the stages of the election.
Barrister, we will come back to you. Let's quickly take a call. Babi Dele from
285.
Babi Dele is calling. Babi Dele, can you tell us where you are calling from, please?
How are you telling me?
Bamidele is calling from Abuja. Jikwe, thank you so much. So just tell us, just give your point. Make your point, I beg your pardon.
Actually, you know, the issue of arguing about the cancellation of the governorship of Ebonyi State, I don't think the learned policy, they are not supposed to be arguing about it because the issue is very clear. Number one, that is not like independent candidacy. That is, they have not been allowed in our law. So, a vote cast belongs to the party. Because if it is because of the popularity of the candidate featured by the party, has it been the law that the independent candidate has been allowed? The person can go and contest on their own without doing so on the platform of any political party. But because there is nothing like that in the law of the land, so the vote cast there belongs to the party. So the issue of impunity, actually, according to the law, he is not supposed to be the governor of that state. With what not to talk of the immunity. You have to be a governor first before you talk of immunity.
All right, thank you, Bamidele.
Governorship is non-avoid, so you can't talk of immunity.
Thank you so much, Bamidele. So your parting word, we're running out of time already.
Well, the issues are simple. It is in the media now that the governor has gone
for appeal.
Yes, he has appealed the judgment. That is ordinarily what is expected of any person in a democratic and situation in a state, in a country guarded by rule of law. Since he has taken that step, the Court of Appeal now is vested with jurisdiction to also look at it. But Nigerians should note that the judicial activism of Justice Ekwo has raised issues, but on most cases, when it goes upstairs, the justices of the court of the appellate courts have always found wisdom in what he says. And I hope in this one too, they will see the wisdom of what he has done and the mischief he has cured in our polity. Thank you.
10 seconds.
To me, because there is no constitutional backing to that judicial exercise, it's like, according to the Newton scientific law of gravitation, you cannot put something on nothing and expect it to stand. It must crumble like a pack of cards. There is no authority, constitutional authority upon which that judgment evicting the governor for Ebonyi State stands.
Right.
So he stands the right to enjoy and occupy the office of governor of Ebonyi State until the processes of appeal is exhausted and terminated at the Supreme Court of Nigeria.
Okay,
if you remove him as a governor by virtue of this judgment, you have denied him his right under section 240 and 241 of the Constitution of Nigeria, which is appellate right.
Thank you so much. We'll be speaking with two lawyers here. Barrister Vincent Otapupu, thank you for coming on the show.
Thank you.
And also Barrister Tochukwu Ohazurike, thank you so much.
Always a pleasure to be here.
Well, let's just quickly take one or two messages. This is coming from Oku E in Abuja. He said,